We have two, actually, yes. And as I understand it, Senator Monning will be presenting on behalf of Senator De Leon. So let's go ahead, Senator Morlock, with your bill, file item 7, and we will conclude with Senator Monning presenting file item 12. Senator Morlock.
Thank you, Madam Chair. It's an honor to present to this committee. This bill is about the American Disabilities Act, and as Madam Chair, you stated earlier, this is to address a matter of fairness. So for those who are disabled and also for those who are operating businesses. Just 2 weeks ago, the San Jose Mercury News had 2 excellent articles by a reporter by the name of Matthias Gaffney on the ADA lawsuit abuse topic. They told of a nightmare for 2 business owners that they faced with ADA concerns. One was Samir Misson, who made a $300 fix to his gas station, and then he received a $25,000 demand settlement from an attorney, the owner of an organization known as Disabled Access Prevents Injury, Inc. This attorney has filed thousands of ADA lawsuits across Northern California. In fact, he had staff that had quotas, that had to drive around towns to just find places to litigate that were targets. One legal expert in the article summarized that these cases are all about attorney fees, not about ADA. The Orange County Register had a headline in its business section that read, "ADA suits a drain on businesses." Colleagues, the date of this article was March 15, 2000, 16 years ago. This issue is still here after all this time, and we still have what I would consider legalized extortion. It was one of my earliest constituent contacts where someone called and said, or contacted me and said, you know, the business next door just got a high demand letter, and what can you do to help out? So we all know that ADA is critical, but it should not be a vehicle for intimidation and personal gain. If a business is deficient in ADA requirements, then please give the owner a right to cure. Let the business fix the issue within at least 120 days. Let these small business owners, the mom and pop shops, correct any and all non-compliances. And when there is a conflict between the federal rule and the California rule, we're requesting that the federal rule preempt the California rule. Suits are filed for bathroom mirrors being 1.5 inches too high, or that the business had the wrong shape for the handicap sign on the bathroom door. We've seen handicap parking space signs being the wrong shade of blue. We've had faded paint for parking lot stalls. And thanks to the Unruh Civil Rights Act, plaintiffs are entitled to a minimum of damages that can start as high as $4,000 per violation, triple the damages, and may be awarded attorney's fees, all for a $10 mirror fix. What's the point of compliance law if you can't afford to fix the compliance? You got to be stuck paying demand letters as opposed to fixing the problem to help people access your business. Also, with the California version of the ADA, which is called the Construction-Related Accessibility Standards Compliance Act, there may be differences. Thus, there should be a default, and it should be the federal version. Let's help our disabled population. Let's help our small businesses. I'm honored to have many reputable organizations in support. I've been surprised with how many have contacted my office in support of this bill and even received nice editorial support. And I have 2 witnesses here today in support. Rachel Golden, who has driven all the way up from Fresno to speak on the matter, and then business owner Martha Perez, who's come all the way from Jackson and Amador County to present. So thank you, Madam Chair.
Thank you very much. Witnesses, good afternoon. Thank you for your patience. 2 minutes each, if we could.
Hi, my name is Rochelle Golden. I'm an attorney in Fresno, California. As somebody who suffered a snowboarding accident as a teenager, I'm intimately aware of what the ADA set out to accomplish. I'm intimately aware of what the Unruh Act set out to accomplish. Discrimination on the basis of disability is preposterous, but at the same time, as a defense attorney, I realize that this has gone too far. There needs to be a balance between providing accommodation, which is truly what the ADA is about. It's not about mere heights. It's not about counter heights as specified in the California Building Code. It's about accommodating somebody with a disability, and most businesses, if you speak with them, will do that if they know what the violations are. So this bill will help give businesses the tools and the opportunity in order to understand what potentially their barriers could be, as opposed to getting hit with a lawsuit and then being forced to pay a settlement when they now no longer have any money left, potentially, to build the ramp or to lower even the $10 mirror, but they've just handed over basically a check for somebody that potentially is, and most likely has never even entered the facility in the first place. So this bill would give 120 days for the notice and opportunity to cure. And like I said, if you ask any business owner, they will say, why didn't somebody tell me? If I would have known, why didn't anybody tell me? And this bill provides that appropriate balance between providing accommodation as well as correcting any potential barriers that may exist under California law. Thank you.
Thank you very much. Well done, and within 2 minutes. Very good. Good afternoon.
Good afternoon. Thank you for having me. I appreciate it. In 1983, I opened my restaurant, Jose's Mexican Restaurant in Jackson. And one day in 2002, there was a gentleman in crutches that knocked on my door while I was doing the vacuum. I opened the door for him, let him in, asked me if he could use my bathroom. And I said, yes, of course. 2 weeks later, I had a lawsuit. And another 2 weeks later, I had a brain aneurysm from the stress. I did everything they asked me to do, and it wasn't good enough. They still wanted $150,000, and I worked so hard. I can't come here all the time. I work very hard to maintain what I have, and to see this happen, not even an opportunity to give me a chance to fix it. For God's sakes, you know, it's just not fair. I came to this country to be an asset to this country. I didn't want to be anything else, and I work very hard for what I do and for being compassionate to somebody opening my door. My brain aneurysm, I almost killed me. I had insurance. The guy that sold me my insurance had no license to sell insurance, so I ended up filing Chapter 13 because of the stress that he gave me. And Chapter 13 is where you pay back, you know, because I couldn't go to the country and put my hand out. I didn't come to this country for that. So all I'm asking you guys is to help all the businesses, small businesses. This law did not exist when I opened my business. Nobody notified me. I'm stuck in my business, working, trying to maintain my business so I can pay my taxes and my employees and keep them working hard so they don't have to put their hands out either. And so 33 years in July, I have had my business and done the best that I can. So all I ask you is to please give other businesses the opportunity so nobody has to go through what I went through.
Thank you for your testimony. What year was it that you were?
2002.
2002.
2002.
A lot has happened since 2002.
Yeah.
We know that there have been predatory lawsuits that were filed by one or two firms.
In Jackson.
That's right, the Trevor Law Firm that was sort of shaking down business owners, and we put them out of business and put them in jail. And hopefully we have taken major steps since 2002. In fact, there was a bill passed last year by Assemblymember Stone to address, I think we call it the problem with litigious, what do we call it? High-frequency litigants whose goal is to go around and to just sue people.
The gentleman that's...
We've taken them out of business. So appreciating that there have been abuses in the past, we really have been working on that, and I'm glad to see you're still in business and that knock on...
And I'm going to stand for all the small businesses in California every chance I can.
Thank you very much, and we appreciate it.
Somebody has to. It's hard to come here. I'm not used to sitting down so long. I was like, oh my God, I gotta go to work. Gotta go to work.
Take a deep breath, and
know.
are there any other witnesses that would like to testify are we in support or opposition? Support of this bill.
Jennifer Burr on behalf of the California Chamber of Commerce in support.
Thank you.
Chris McHaley on behalf of the Civil Justice Association of California in support.
Thank you.
Ken DeVorth, the National Federation of Independent Business in support.
Thank you, sir.
Jason Schmelzer on behalf of CSAC Excess Insurance Authority in support. Thank you.
Thank you. Witnesses in opposition, if you would step forward. Grab a seat. Where would you like? Can you make it? That's good? Okay. And we have another person in opposition, so if we could just, thank you very much.
I get to do this again.
You do.
I do. Thank you.
Good afternoon.
Good afternoon. I'll keep my comments brief. I'm Evelyn Abuhasan with Disability Rights California. I'm an attorney and a lobbyist with the organization, been there 15 years. We are a cross-disability organization. I'm going to make a few comments. I think the analysis actually highlights it well. This bill, like many predecessors before it, treats people with disabilities differently. It essentially says you have to go through a series of barriers before you get to exercise your civil rights. That means that my civil rights as a person with a disability don't matter. I am a protected class. Just like women, just like people of color, we are a protected class under the law. We should not have to go through additional barriers to exercise our rights. The laws have been on the books for a long time. Businesses have a responsibility to educate themselves about what the laws are. This is not a policy we should be promoting in the state of California to give businesses more time to fix, rather than being proactive about how to address access issues and ensure that people with disabilities have equal access and are fully integrated into our society. With those comments, I'll conclude and turn the dais over to my counterpart here.
Thank you very much.
Madam Chair, members of the committee, thank you. My name is Jith Meganathan. I'm a policy advocate with the Western Center on Law and Poverty. We are opposed to SB 1142, and in particular the requirement that in the event of a conflict between the federal ADA and any state law, standard, or regulation relating to disability access to public accommodations, that the ADA should control. There's an important federalism principle at work here. California has been a leader in safeguarding and furthering rights and protections for people with disabilities. We should be free to innovate above that floor. This bill would instead treat federal law as a ceiling that limits how high we can rise. Without diminishing the numerous challenges that disabled Californians face and the progress that remains to be made, we should be proud of what we've done and continue to build on it. Why would we want to tear it down instead? Thank you.
Thank you very much. Other witnesses in opposition?
Thank you. Good afternoon again. Nancy Peverini on behalf of the Consumer Attorneys of California. I just wanted to let the committee know that we understand some of the issues raised by the author on this bill, and that's why we partnered with the California Chamber of Commerce to get a bill through the Senate that was actually passed out yesterday and is headed to the governor to address some of the identified problems, but without while we try to maintain the integrity of this important law. We think it creates a good balance, and we're hopeful that the governor will sign it and address some of these few handful of lawyers who really are seeking fees and not compliance. Thank you.
Thank you very much. Other witnesses in opposition? All right, we'll bring it back to the committee. I appreciate the concerns that are articulated. One of the issues we've tried to discuss is this really isn't designed to be a trap. It's just designed to really help people who have obstacles to confront when they access public buildings to be able to access them with the dignity and the respect that anyone else has in that process. We have attempted to emphasize and have landlords, for example, make it clear in leases whether their property is ADA compliant or not. We know that a lot of small businesses don't think about it. They're not aware of it. The goal is not to undermine them and put them out of business. We've been trying to find that balance, and I know that there is that measure now gone to the governor. Hopefully that addresses this problem. I have my own personal experience when I was looking for offices in my local community for my state office after I got elected to the Senate. It was very difficult to find buildings that were ADA compliant. And I was told, well, actually, they were surprised that I even raised the issue. I said, I'm a state senator. I have got to know about this issue because there are so many instances where people don't know whether it's because we haven't given them good information or what, but there are people who are not aware of it. And I can't tell you how many landlords would say to me, you have to assume the liability, but it's your building. Anyway, it's been a battle back and forth, and so I had that personal experience. I refused to participate in any facility that was not ADA compliant. There were very few that I could choose from, but after many weeks, months actually, I found a building that was ADA compliant. But this is a journey that I think many of us who care deeply, and I think most businesses absolutely don't want to deny access to people. They don't want, they want you to be a customer or a consumer or whatever. On the other hand, you do, the class of disabled Californians is a protected class, and we have to respect that. But I don't think giving these companies 4 months after they're told is the approach to take. And I do have confidence knowing that the consumer attorneys came together with their frequent adversary to come up with something that does create the balance. That it's my hope that we have moved forward with that. And for those reasons, I can't support this bill, but I do believe that most people involved, whether they're the plaintiff in these actions or the disability community and the business community are not out to sort of hurt each other. We have dealt with those few law firms that make this a career to the detriment of the unknowing business community. I think we've dealt with them, and so that situation that happened to you in 2002 would hopefully not happen ever again. While at the same time, we have to respect the challenges and the needs and the priorities and policy the state has had. And I also want to say, I always find it interesting where when it suits somebody to say states' rights, because the federal law is too extreme, or says let the federal control because the state has moved more expeditiously. We just can't have it both ways. So with that, any other questions? Senator Anderson, followed by Senator Monning and Senator Hertzberg.
Thank you, Madam Chair. Those are excellent points. I do have a concern, and maybe you have an answer. You don't have to necessarily answer this, but there are a lot of small businesses who are on limited budgets that are trying to make it. We had a disabled business owner who lost his business because of one of these lawsuits, and yet he was in a wheelchair running that business. And do you believe that there is an appropriate amount of time? If it's not this time frame, is there an appropriate time? Because so often the money ends up in the attorney's hands, but it doesn't solve the problem. And at the end of the day, you still don't have access. And I want you to have access.
So just a few comments. You can't really, so if something is happening that's fraudulent, you really can't legislate fraud, and you can't, you have to be knowledgeable about what's a fraudulent ask. So if someone takes money and then doesn't fix the problem, that's fraud. That's not legislated, and you have to educate yourself as a business owner that, I don't have to pay someone off. But I think the better approach really is to look at how can a business be proactive to ensure access for people with disabilities. What that looks like is getting your business inspected by a certified access specialist, which are available in the state pursuant to the CULE bill from 2000 and, don't quote me, 3, SB 252, which allows a business to voluntarily hire a CASP, which is an inspector, to go in and look at their business, to show them areas that are out of compliance so that compliance can happen. Being proactive up front is going to address a lot of these issues. But the business has to have a willingness to be that proactive party to work with the disability community to address access in that way.
One of the difficulties that businesses in my district speak in terms of, they'll hire that service, but if you don't hire the service, you're compliant today, but these rules and regulations change all the time, monthly. And, perhaps if we moved in a direction that they could be implemented only at certain times of the year so everyone would know, hey, I can check today to find out what the story is, that might be helpful to the business who's trying to comply, who's really wants to earn your business. I'm just trying to find where that place is, because last year there were 9 lawsuits in my district, and even though we've done a lot up here, it hasn't stopped all the drive-by lawsuits. And I'm just worried that at the end of the day, you don't have access and other people don't have access. You all deserve access. And that's why in the past I wrote a bill that said that the California websites had to be, because we don't meet ADA. The state of California is absent in making ADA. And kudos to the chairwoman for holding out for an office. But in most districts, I think if you inspected our offices, we fail to meet ADA. So I appreciate your testimony, and I was just looking for that sweeter spot, because I hate to see people being put out of business when they're doing everything they can. And, these are all, it's a difficulty when you think because somebody came in and inspected it and said, yes, you're okay. Tomorrow the law's changed, and you think that you're okay. And I was shocked, to be honest with you. For years, I always thought that the owner of the building was responsible, not me as a person who's simply renting a room or renting an office. Then I find out I can be in that lawsuit as much as the next guy, and I had nothing to do with it. In fact, it's on the other side of the mall. I'm on this side of the mall. So, without me going through and inspecting their property, it's a lot of pressure on a small business.
And I do understand that. And again, I'm really talking about shifting the dialogue so that there's some collaboration between the disability community and the business community. Just on a personal note, my father was a small business owner and a non-English speaking small business owner. So I understand that side of the story. But at the end of the day, people with disabilities are entitled to access. And I don't think anybody would disagree with that. So the discussion that I would like to see happening, that the disability community would like to see happening, is how do we come together to address this in a way where we're not curbing civil rights and still looking at proactive ways to address the issue.
I agree. Thank you for that. I have a question of the senator. I don't know if you can answer this or not, but your witness earlier, the attorney that sued her, is he still in practice, or is he continuing to sue people? Do you even know the answer to that?
Neither of us know.
Okay. Thank you very much.
All right, Senator Monning, I believe, was next up.
Thank you, Madam Chair. Well, I want to thank the senator for joining in what's been a chorus in recent years here in Sacramento in trying to find the balance. As was mentioned earlier, Senator Roth's been working on a bill for 2 years that I supported on the Senate floor the other day. I believe that reflects, by its co-sponsorship of the Chamber and consumer attorneys, a negotiated agreement. I think it's important for listeners, for the woman who suffered such injustice in her business, to recognize we're not starting from scratch. As the analysis for this bill is really good, kudos to the staff. It does cite much of what's been achieved in recent years. So statements that people are doing drive-by demand letters and shaking people down for $25,000, if that's happening today, it's illegal. And it's illegal because we've passed laws that say you can't do that. You have to provide the time to repair. And attorneys that engage in that are under the scrutiny of the state bar now. Those demand letters can be filed with the California State Bar. So clearly there's more work to do, but I think there's momentum and partnership and participation of stakeholders reflected in the current bill that's going to the governor's desk. For that reason, I won't be able to support this bill today. I want to give that one a chance. And I do just want to respond to my colleagues' comments about our offices. I have a district 6,000 square miles. I have 3 offices. Senate rules will not sign a lease with a landlord who has not, where our own inspectors haven't confirmed that it's ADA compliant. And that's true for every Senate office where the state of California is paying the rent. So I just want the record to reflect that we're not setting one set of standards that we're not living by. The building we work in is ADA compliant, and those adjustments were paid for by taxpayers to advance good public policy to make state buildings and offices accessible. So with that, I thank you, Madam Chair.
All right. Anyone else? Senator Hertzberg.
Briefly, Senator Monning, just associate member Marks, he mentioned most of the things that I was going to mention here. You know, I mean, I just hate gotcha government. I mean, it drives me crazy. The fact that this testimony, when she says, for God's sakes, I mean, that's a really important thing. We've just somehow lost our common sense in terms of how we apply the law. But I think that, you know, I went and looked and compared the Roth bill. Roth's a co-author on your measure, and what are the underlying issues? I mean, other than the federal piece, which I agree with what was mentioned here earlier, I don't think that giving up jurisdiction for the feds, 120 days, the idea of the in-state architect to inspect, which really deals with the issue of good faith. What you don't want, seems to me, is somebody who just ignores and thumbs the nose at the law and doesn't care, figures, I got 120 days, who cares? There should be some mechanism in there, which I think is written in the law, what Roth did, Senator Roth did, that says if you're a bad actor, you don't get the benefit of the delay, but if you're an innocent bystander, who all of a sudden, you know, realized they did something wrong. Because we've all seen these inspectors. I had an 1.25 inches off on a toilet in my own private bathroom and had to move everything, right? Where it was only for me in my private office and nobody else to use it. You see these inspectors that do this kind of stuff. But I think that your method is, your approach is intelligent in the sense that this is something that we need to do. I do agree that with respect to what Senator Monning indicated, we've got this bill. Senator Roth, when I talked to him on the floor the other day, he says it's been very challenging. And to pull the coalition these pulled together, Brian Kabatak up here on behalf of the lawyers, this chamber coming together to really to deal with this issue that says, you have a right to cure, that our government is not to just stick it in people's eyes, but if they're innocent players, you shouldn't nail them and give them an opportunity, but not to be repeat offenders. So I think you get to that. But we are in a situation, hopefully, with Senator Roth removing, Budget Chair just told me Senator Roth removed the tax credit issue, which was a component which was the governor vetoed on last time, that maybe we'll get that and move this substantially forward. So I really appreciate your discussion in this regard.
All right, Senator Leno.
Yes, thank you, Madam Chair. I will be careful not to repeat all that has been stated because this is an issue that the legislature has been dealing with for many years, many attempts to improve upon the current situation for small business owners. But I do want to pay respects to Disability Rights California, because even though this Roth bill was a negotiated compromise over the objections and graciousness of Disability Rights California, who does not support the compromise, and I remember clearly your arguments why. Yeah. Correct me if I'm wrong. In all other cases of law where someone discriminates, there's no right or time to cure. Mm-hmm. We did this specifically in this situation because the need was so great to do something for small business owners. But why, again, are those from the disability community treated differently? And that's from your perspective, I recognize a flaw in the Roth bill. So you've been very gracious about this. You're not a part of this compromise.
And just so that we're clear, we did come to the table with Senator Roth and have conversations as to his bill, regardless of our opposition. Disability Rights California always comes to the table to be part of the negotiations to try to get to an end result. That being said, we are in opposition to that legislation.
Right. For the reasons
you stated, among others.
So the reason for my comments are just to recognize your graciousness in this whole conversation. It's not an easy one, but there's none of us who do not have small businesses in our district, who were not abused by these attorneys, and we've come together to do something about it.
All right, with that, I think everyone has had their say. Oh, I'm sorry.
Just for a clarification, Cover California, their website does not meet ADA standards. Most of the state's websites, in fact, if you were disabled and you wanted to apply for a contract with the state, you couldn't read their website because it's not ADA compliable. And I think if you go through most of our offices here in the Capitol, I think some of those are not ADA.
Well, that may be the source of a bill.
I just want to make sure that people understand it. I'm glad that we've moved forward in district offices, but that's not true of every office.
Well, that might be something we should look into. With that, is there a motion?
I'll move that bill.
All right, there is a motion. Madam Secretary, the motion is due pass. I think we've had an exhaustive discussion about this. If you can do it in 30 seconds, would you like to?
He's not a lesser citizen. He's a senator.
Senator, I have the gavel. Thank you very much. If you can close briefly, Senator, would you be willing to do that?
I will do that.
Thank you, sir.
Chair, I'll very quickly. I agree. Thank you for the comments and the approach. With Senator Roth, I sat with him and I said, this credit component is going to kill this bill. Please take it out. And he wouldn't. So I voted for it anyway because I believed in what he was trying to do. And when Governor Brown vetoed the bill, it was like, oh, so we called him up and said, we'd like to, are you going to do it again? And if you're not, we'll do something. So that was the genesis of this bill. I co-authored his bill, he co-authored mine. And so we were both concerned. Obviously, it's a national dilemma. There's a bill right now looking for a 90-day cure period in Congress. So this is a national import. For the past 10 years, there have been more disability access lawsuits filed in California than the 4 largest populated states combined: Florida, New York, Texas, and Pennsylvania. There's something going on here, colleagues. California has 40% of the nation's ADA lawsuits, but only 12% of the country's disabled population. And I've talked to so many business owners, minority business owners, that have just been socially crushed. They've been embarrassed. They've had to go to relatives to borrow money, and in their culture, it wasn't like what you do. So they've been shamed and embarrassed. So this is a fix, and we can do it together. We should give the business community a 120-day right to cure, and I urge and I vote.
Thank you, Senator. With that, there is a motion due pass to the Senate floor. Please call the roll.
Jackson?
No.
Jackson, no. Morlock?
Aye.
Morlock, aye. Anderson?
Aye.
Anderson, aye. Hertzberg? Leno? No. Leno, no. Monning?
No.
Monning, no. Wachowski?
No.
Wachowski, no.
All right, that bill has 2 aye votes and 4 no votes. That measure fails. Would you like reconsideration?
Please.
Without objection, that will be the order. All right, we have 1 bill left. Senator Monning. Senator Monning will be presenting file item 12, SB 1351, by Senator De Leon. What's that? All right, our last bill, Senator Monning, if you'd like to proceed. Thank you, folks, for coming and testifying. We appreciated your willingness to share your stories. And now, Senator Monning, please proceed.
Thank you, Madam Chair. Members, I'm presenting on behalf of Pro Tem De Leon. SB 1351 removes the term of alien from the statutory provision in the Civil Code that provides for equal property rights for all people. Both the California Constitution and existing statutory law afford equal property rights to both citizens and non-citizens. The Civil Code codifies that any person may take, hold, and dispose of property within the state, regardless of whether citizen or alien, close quote, that is, regardless of citizenship. This measure would replace the word alien, an outdated term for a person not born in or naturalized citizen of the United States, with the term non-citizen. This change does not in any way impact the significance of the statute. It simply intends to use a more appropriate term to more accurately identify the population that this statute confers rights upon. Today, that term carries negative connotations of otherness that California has sought to disavow in recent years in order to affirm its commitment to full immigrant integration. On behalf of Senator De Leon, respectfully ask for your aye vote, and with the chair's permission, would like to present witness in support.
Hi, good afternoon. My name is Joseph Villelav on behalf of CHIRLA, the Coalition for Humane Immigrant Rights in Los Angeles. In our perception, words matter. As we know and we're witnessing in this political season, which is picking up, the words illegal, alien are coming to divide, harm, and dehumanize immigrant communities who are not citizens but who have deep roots in our country. This bill replaces the word quote-unquote alien, an outdated term for a person who is not born or naturalized in the United States. This bill recognizes the contributions of immigrants, but most importantly recognizes that California is moving in the right direction to make sure that new Americans are integrated, but most importantly are humanized. And for that, we respectfully, you are vote. Thank you.
Thank you very much. Any other witnesses in support? Any witnesses in opposition? Any questions from the members? Senator Morlock.
Thank you, Madam Chair. As someone who immigrated to the United States, and maybe a little older, I've never been offended by the term alien. I've always considered myself an alien, so I appreciate the bill, but we've had this discussion, we had it last year with the Mendoza bill. So I just wanted to say that for some of us, we're still kind of proud to be called an alien, but I'm glad to be a citizen, so thank you, Madam Chair.
Thank you. Any other comments? All right. Is there a motion? Senator Hertzberg has moved the bill. Please, let's see, the motion is due pass to the Senate floor.
Ask for an aye vote.
Thank you, sir. All right. Please call the members.
Jackson?
Aye.
Jackson, aye. Morlock? Morlock, aye. Anderson? Anderson, no. Hertzberg? Hertzberg, aye. Leno? Leno, aye. Monning? Monning, aye. Wachowski? Wachowski, aye.
6-1, that bill is out. We're going to just call through the calendar for, through the bills for those who have not voted and who would like to vote very quickly. We have file item, what is this, the consent calendar? All right, we'll do the consent calendar. I'm sorry, is that the consent calendar? All right, the consent calendar, file items 6 and 9. Please call the absent members. The vote count is 5-0. Absent members on the consent calendar.
Anderson? Aye. Anderson, aye. Hertzberg? Aye. Hertzberg, aye.
All right, 7-0. The consent calendar is adopted. Next item is file item, yes, the consent calendar is out. File item 1. Senator Monning, that measure is out on a 6-1 vote. Wachowski, excuse me. They do. Seen one lawyer, you've seen them all. All right, file item 2, that is out as well, 6-1. File item 3, that is out as well, 6-1. File item 4, the vote count is 5-1. You want please call the absent members.
Morlock?
All right. File item 4 is out 5-1. File item 5, vote count is 6-0. Please call the absent members.
Monning? Aye. Monning, aye.
That item is out 7-0. File item 7, that bill failed on a 2-4 count. Reconsideration was granted. File item 7? 8. All right, the vote count is 5-1. Please call the absent members.
Hertzberg? Hertzberg, aye.
The bill is out 6-1. File item 10. Senator Hertzberg, there's... actually, that motion, that bill failed and reconsideration was granted. File item 11. That bill is out 6-0. File item 12, that bill is out 6-1. I believe that concludes our calendar. We are adjourned.